When putting together a legacy plan, what should I consider when deciding to use a will or a trust? So I'll see if you might have mentioned some of this earlier.
Well, I did tell John, if he was listening earlier, that when you go to probate, it's a public process.
Right.
Everything gets listed on the public record. So if there's anything you don't want people to see, you should not list it there. You should avoid that. It takes about 2 years to go through probate, costs about 5% of your assets. So that would be $50,000 on $1 million estate.
Mm-hmm.
Now, a solution to avoid that can be a trust. Here's the problem with trust, Ralph. They tend to be complicated for people to administer just because they aren't familiar and accustomed to operating as trustees. And so it kind of confuses them. So unless you have something specifically in your family that you're trying to protect against, a trust might be killing a mouse with a sledgehammer and it might not be necessary. But in cases where it's appropriate, I prefer a third solution where you make sure that every asset has a beneficiary named. All your accounts, your cars, and your real estate in Missouri can all be distributed by simply naming beneficiaries. And you have to do it legally in proper legal form. You can't just write it on a scratch pad and tell the kids that's the way you want it done. This can be the simplest, least expensive way of getting your estate to where you want it to go. And if you need help with that, we'll call us at WealthCare and we'll get you pointed in the right direction.